The Supreme Court is about to make a decision that could change gun rights in America forever, and what just happened at the Department of Justice is making it almost impossible for them to ignore. I'm talking about assault weapon bans potentially being struck down nationwide, and the dominoes are falling faster than anyone expected. If you own an AR-15, if you've been watching state-level gun bans spread, or if you care about the Second Amendment at all, the next 6 months could reshape everything. Let me show you exactly what's happening right now. Before we dive into the details, are you subscribed? Because the Supreme Court could announce whether they're taking these cases any day now, and when that happens, you'll want to see my breakdown immediately. Hit that subscribe button right now so you don't miss the moment that could change gun rights forever. Here's what just happened. The Department of Justice, under the new administration, just filed a lawsuit against Washington D.C.'s assault weapon ban. Now, you might be thinking, so what? The DOJ sues people all the time. But here's why this is absolutely massive. The DOJ created an entire new section called the Second Amendment section, specifically to challenge gun bans across America. This isn't some random lawsuit. This is a coordinated strategy to dismantle assault weapon bans permanently. Let me paint you a picture of what's sitting on the Supreme Court's desk right now. There are multiple petitions asking the court to rule on assault weapon bans. Two big ones are Viramontes versus Cook County, which challenges Illinois' ban, and National Association for Gun Rights versus Lamont, challenging Connecticut's ban. These cases have been relisted at Supreme Court conferences multiple times. When the court keeps relisting a case instead of just denying it, that's a signal. They're thinking about it. They're discussing it behind closed doors. Justice Brett Kavanaugh already tipped his hand last June. When the court denied a Maryland assault weapon ban case, Kavanaugh wrote a statement saying he doubted the lower court got it right. But here's the kicker. He said the court should address the AR-15 issue in the next term or two. Well, guess what? We're in that window right now. Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch all voted to take that Maryland case. That's 3 votes. You only need 4 to grant a case, 1 more justice, and this issue goes before the Supreme Court. Now this is where it gets wild. The DOJ's lawsuit against D.C. isn't just about D.C. residents. It's about setting up the perfect Supreme Court case. Think about it. When the DOJ, representing the federal government, argues that assault weapon bans are unconstitutional, that carries massive weight. Lower courts have been all over the map. Since the Supreme Court's 2022 Bruen decision changed how gun cases are decided, some courts say AR-15s are protected because they're in common use. Other courts say they're too dangerous. The legal landscape is a mess, and everyone knows the Supreme Court has to step in eventually. Here's the part everyone misses. There are over 20 million AR-15 style rifles in America right now. That makes it the most popular rifle in the country. Under the Supreme Court's own test from the 2008 Heller decision, the Second Amendment protects arms that are in common use for lawful purposes. 20 million rifles. That's not rare. That's not unusual. That's common use by any definition. Yet 10 states have banned them anyway, and the lower courts keep upholding those bans by calling these rifles too dangerous for civilians. Let me show you the strategy that's unfolding. The DOJ files lawsuits in multiple jurisdictions. These cases work their way through the courts. Different circuit courts issue different rulings. That creates what lawyers call a circuit split. When circuit courts disagree on major constitutional questions, the Supreme Court almost always steps in to resolve the conflict. It's not a matter of if, it's a matter of when. Wild fact, over 70% of viewers watching aren't subscribed. If you want to know the moment the Supreme Court announces they're taking an assault weapon ban case, you need to subscribe now. I'll break down exactly what it means for your state and your rights the second it happens. Don't miss out. Hit that button. So what exactly is the Supreme Court waiting for? Justice Kavanaugh gave us the answer. He wanted more circuit courts to weigh in first. Well, that's happening right now. The 7th Circuit upheld Illinois' ban. The 4th Circuit upheld Maryland's ban. The 9th Circuit is expected to rule on California's ban soon. The courts are splitting. The legal chaos is mounting. And the pressure on the Supreme Court to take action is building every single day. But there's something bigger happening that nobody's talking about. The Supreme Court's 2022 Bruen decision fundamentally changed how gun laws are evaluated. Before Bruen, courts used what's called intermediate scrutiny. Basically, if the government had a good reason for a gun law, it would probably be upheld. Bruen threw that out completely. Now, the government has to show that gun restrictions align with America's historical tradition of firearm regulation from the founding era. That's a much, much higher bar. Here's why that matters for assault weapon bans. When you look at the founding era, there were no bans on military-style weapons. Citizens could own the same rifles the military used. In fact, they were expected to. The whole point of the Second Amendment was to ensure citizens could resist tyranny, and you can't do that with inferior weapons. Now, I'm not saying the Supreme Court will definitely strike down assault weapon bans, but under the Bruen framework, The government has to find historical examples of banning the most common military rifles of the day. Good luck finding that. Banning the most popular rifle in America from being owned in your own home for self-defense. The analogies don't work, and legal scholars on both sides know it. Let me give you a real example of how this is playing out. In the DOJ's lawsuit against D.C., they point out that D.C. requires gun registration, but then refuses to register AR-15s and similar rifles. So you're not technically banned from owning one, but you can't register it. And if you own an unregistered gun, you face arrest. It's a ban disguised as a registration scheme. The lawsuit argues this is exactly what the Supreme Court struck down in the original 2008 Heller case, which also involved D.C.'s gun laws. It's the same city, the same constitutional violation, just a different year. Here's what most people don't realize. When the Supreme Court ruled in Heller that D.C. couldn't ban handguns, the decision specifically said the Second Amendment protects arms in common use. But the court didn't define common use with a specific number. How many Americans have to own something before it's in common use? 1 million? 5 million? 20 million? The court left that question open, and now, with AR-15s being the most popular rifle by far, the court has to answer it. If you're enjoying this breakdown, wait until you see my next video on what happens to state-level gun laws if the Supreme Court strikes down assault weapon bans. Subscribe so it hits your feed first. You'll want to see that analysis the moment it drops. Now let's talk about the timeline. The Supreme Court's current term runs through June 2026. The justices have probably finished selecting which cases they'll hear this term, unless they decide to fast-track something. That means these assault weapon ban cases are more likely to be decided in the 2026-2027 term, with a ruling coming in spring or summer 2027. But here's the wild card. If the DOJ's lawsuit against D.C. moves quickly, and if it creates enough urgency, the court could potentially fast-track the issue. There's also another scenario playing out. Multiple states are passing new assault weapon bans right now, even knowing the Supreme Court might strike them down. Why? Because they're betting on delay. Every month these bans stay in effect is a month where residents can't buy these rifles. Even if the bans eventually get struck down, they've already achieved years of restrictions. It's a calculated risk, and it's making gun rights advocates furious. Here's the biggest mistake people make when following Supreme Court cases. They think a ruling will be simple. Either assault weapon bans are constitutional or they're not. But Supreme Court decisions are rarely that clean. The court could rule that bans on AR-15s specifically are unconstitutional because they're in common use, but leave room for states to ban other features or require certain safety measures. Or the court could set a clear common use standard that applies to all firearms. Or they could punt on the issue entirely and send it back to lower courts for more analysis. This is why the DOJ's involvement is so critical. When the federal government takes a strong position, it influences how the court frames the question. The DOJ isn't arguing for some middle ground compromise. They're arguing that commonly owned semi-automatic rifles are protected, period. That's a maximalist position, and it shifts the entire debate. Let me show you what's at stake state by state. California, Connecticut, Delaware, Hawaii, Illinois, Maryland, Massachusetts, New Jersey, New York, and Washington all have assault weapon bans. That's 10 states affecting over 90 million Americans. If the Supreme Court strikes down these bans, we're talking about the single biggest expansion of gun rights in modern American history. Millions of people who currently can't buy an AR-15 would suddenly have that right restored. But wait, there's something even bigger. These same states also ban what they call large capacity magazines, usually anything holding more than 10 rounds. Those bans are also being challenged using the same common use argument. Standard capacity AR-15 magazines hold 30 rounds. If those magazines are in common use nationwide, then states can't ban them either. The Supreme Court has been relisting magazine ban cases too, which means that issue could be decided at the same time. Here's what nobody's telling you. The real fight isn't about AR-15s, it's about whether states can ban anything that's popular nationwide. If California can ban AR-15s, despite 20 million being owned across America, what else can they ban? Semi-automatic pistols? Standard capacity magazines for handguns? The precedent goes way beyond rifles. Gun control advocates know this. Gun rights advocates know this. And the Supreme Court knows this. That's why this decision is taking so long, and why the justices are being so careful. Things change fast in the gun rights world. One Supreme Court announcement can shift everything overnight. Subscribe now so you never miss critical updates that could affect your Second Amendment rights. Seriously, do it now before you forget. Now let's talk about what you should be doing right now. If you live in a state with an assault weapon ban, understand that these laws are still fully in effect until a court says otherwise. Don't go buying a banned rifle thinking the Supreme Court will protect you later. That's not how this works. But you should absolutely be following these cases, contacting your representatives, and making your voice heard. Public pressure matters, especially when the Supreme Court is deciding whether to take a case. If you live in a free state without these bans, pay attention anyway. Because if the Supreme Court upholds assault weapon bans, your state could be next. Gun control advocates are watching these cases too, and if they win, they'll push bans in every state legislature they control. This isn't just about the 10 states with current bans. This is about setting the rules for all 50 states going forward. Here's the bottom line. The Supreme Court has been avoiding the assault weapon ban question for years, but they're running out of room to dodge it. Lower courts are split. The DOJ is actively challenging these bans. Gun rights organizations are filing lawsuits in every circuit. The pressure is mounting from all sides. Justice Kavanaugh said the court would address this issue in the next term or two. We're in that window right now. What we're watching is the setup for one of the most consequential Second Amendment cases since Heller in 2008. The DOJ's new strategy of directly challenging these bans, combined with the Supreme Court's own framework from Bruen, has created a perfect storm. Something has to give. Either the court takes up these cases and rules definitively, or the legal chaos continues and more people's rights remain in limbo. Don't let this information sit unused. If you care about this issue, get involved. Follow these cases. Support organizations fighting these battles in court. And most importantly, stay informed. And if you haven't subscribed yet, do it now. My next video drops in 48 hours and covers exactly what happens to gun laws in your state, depending on how the Supreme Court rules. You won't want to miss it. Thanks for watching, and I'll see you in the next one.